the thing is, I'm not an animal lawyer. Um, I host the Animal and Law Chair in Antwerp, which was attached to my field because I'm researching the law on personhood, uh, like Visa does and did in his magnificent PhD. It's a very commendable book. But I look at animal law and legal status of animals from a perspective of the broader law on personhood and family law. That's one thing. It's it's a position that pleases me because it allows me to take a somewhat broader perspective to avoid being really in this in if I called it a bubble, um, looking at it from the outside, which is very comfortable. The best critique is given from the outside. So I will try to give this broader perspective. Animal and law chair. Okay, I explained that. So what we are researching in the chair on the law of persons and family law is legal status of entities of all kinds of human life, but of all kinds of non-human life as well, amongst which animals, but also other entities. Um, so I want to spend, what time is it? 10 minutes to a problem, to explaining a problem. But Visa actually did most of that, and much of it is what I was going to say was comparable, and is still comparable. But I am then trying to take an external look at it, and then to also spend 10 minutes on a solution if I get there. Um, um, this is work I'm doing together with a philosopher, Mariano Croce, an Italian in La Sapienza, also well known to Federico. So this puts me at risk, of course, because I'm not a social philosopher or a political philosopher. But that is what I also want to spend time on. To already summarize what I will say is that the discussion on personhood or thinghood of animals as other non-human entities is for me outdated and remains within a tonality of modernity, where we started with the big divide between persons and things in modernity, and we keep reasoning within that same framework, which is also my framework as a continental private lawyer. But then a solution, not the, of course, could be to step outside that framework. And that is the framework I've developed. I'm developing with Mariano Croce to step away from the, what did you call it, totalistic views on legal entities, and approach it from a less hierarchical, as Sabine, I will give you the answer, less hierarchical way, away from rights. I was happy, Professor Broom, that he said, well, no, it's not about rights, it's about duties. That's also what I will try to, no, that's not a summary, I'm explaining everything. And so this is an approach Mariano and I are developing from the perspective of assemblage theory, mostly Latour, Deleuze, and so on. That's what I plan to do. So what is the problem? Here is the problem. The 6 building blocks of private law, as Visa already explained, and what basically is being done now, according to my opinion, in the law on personhood, is to start playing with those building blocks. We start from the idea that only a person can be the subject of rights that come with actions against other persons, and these rights concerns things that can only be the object of rights of persons, but can never be a subject of rights or actions themselves. That's basically, or is a summary of the problem, I think. And then we start playing with these blocks in a way that I think is not leading to a sustainable solution for the problem of the legal status of animals or chairs or rings or anything. looking at this from the broader perspective of the law of persons and family law, if you look into the case law of the European Court of Human Rights on what family life is, who belongs to the web of legal relations, then we see that the European Court of Human Rights is mostly approaching relations from the perspective of living human being, and is making a difference between whether those relations concern other living human beings or other entities. And the clear division is made between other human beings or other entities, a difference that is not always already present in nature, but that is, of course, fabricated by the law. It's the law that makes the difference. It's the law that defines, that creates these categories, and that determines then a fundamental difference in nature on the legal value of relations. So the European Court of Human Rights says, well, law is predominantly, but not exclusively, predominantly, but not exclusively, pertains to living human beings. And then we have all these marginal cases that are somewhere around these clear divisions. And for example, the case law on unborn human life, on deceased human life, and then the court and jurisprudence trying to find explanations why these entities or the relations between living human beings and those entities are to be valued legally. Because, for example, they are a part of the unbreakable chain of human life. The wording is from Gorovtsev in an article of 1926, very interesting article on personhood and thinghood. But the thing is that always, the workaround always happens through the interests of living human beings, or by linking the unborn or deceased life to human dignity as the umbrella concept, or as a future or past personhood. Then there was an interesting case, 1978, on the right to keep a dog, and the claim that the relation with a dog belongs to the realm of family life, which the European Commission on Human Rights denied, saying no, family law does not extend to relationships of the individual with his entire immediate surroundings, insofar as they do not involve human relationships. So what about relationships with non-human entities? Most importantly, and I'm very sorry that this is only a very small part, because it's a 2-day conference about this very topic. You've all written books and so on this, almost a footnote, is that also the relationship with non-human animals enters into the realm of law, but only through a workaround via the interests of the living human beings involved. For example, the right to keep a dog in a rented apartment, or in tort law, as Visa already explained. And then the relations with animals start to enter the legal realm via other ways. All kinds of theories and techniques, like incidents of personhood, the simple res seriostuki, and so on which I'm absolutely no expert and will say no more. But it seems to me that these are very valuable theories and techniques to open the legal realm for animals, or for humans' relations with animals, by using the current building blocks I showed you in the beginning. My work then goes beyond animals as well, like inanimate things like the chair or the rock we talked about on a previous occasion, that also property, like a companion animal, if it were to be considered property, enters the legal realm again by working around the interests of the human beings involved. For example, that the companion animal cannot be seized in seizure proceedings in insolvency law, or that the your grandmother's wedding ring has got a special status in family property law, but always by working around the interests of the living human beings involved. This changes somewhat in more recent strands of research on elements of nature or culture, like the Earth jurisprudence movement, the cultural heritage law. But there again, it's a workaround via the interests of not specific human beings or groups of human beings, but of humankind in general. We're playing around with these traditional building blocks, and we're trouble finding a sustainable solution for the legal status of animals, because we remain within this framework, in which I was talking to a theologian. Where is he now? A theologian during, oh yeah, there you are, Chris, yeah, sorry. During, I said, well, this has to do with the evolution over the centuries of the interpretation of the concept of person, which of course started in Roman times as something completely else than we understand it today via Catholicism and the interpretation of personhood and other religions. And I see you nodding no and then yes, okay. But anyhow, that the concept of personhood has been carnalized or has been humanized over the centuries. I will summarize it like that. And that the relations between humans and things have been de-physicalized, it becoming not a relation between me and a thing, but a relation between me and another person with regard to a thing. So our relation with things has been de-vitalized as well. And now we end up discussing to bring animals or chairs or rings and so on in the realm of law is trying to justify this by defining the concept of personhood. What is a living person? When does life start? Very interesting debate today in the United States. When does life end? I will not give that example, but the lying in state of the Queen is very interesting. Is in a closed coffin. In Belgium, this would be in an open coffin, and there was a big debate when the last Queen died. We have a new Queen, of course, but the last Queen died. She was lying in state in an open coffin, even if she had opposed to that before her death. It was very interesting debate from my field of law, of course. Anyhow, so when does life start? When does life end? How do we look at rights from the interest theory, will theory, or enjoyment theories that are also developed, but still remaining in the same blocks that we are now trying to give a legal position to animals by moving the line between person and thing, like bringing some of the animal things into the category of persons, relativizing those categories, untying being a person and having rights, so a non-person can have rights, or even if you have incidents of personhood, like, but still remaining within the same tonality of this dichotomy between person and thing. This is, I was going to present this as something positive, but then traveling here, I realized, no, it's negative. You start with very clear categories, then you start working with it, and you end up with something that is very blurred. But that is still the same. It's the same. You've created that with the building blocks you have here. And new theories are developed. This is just an example of something hierarchical. New theories are developed in a very hierarchical way. That's the way Mariano and I are working now. It's a work by Thomas Saraceno. I don't know if you know him. He's a phenomenal artist who works, works on the Anthropocene. It's very interesting. Thomas Saraceno says everything is a web. Everything is non-hierarchical, and you should follow the lines in the web. It's like Latour says. You should science, the science of the particular. You should not try to develop general concepts, look at, in an ethnographic way, follow what's happening, and try to develop a legal system on the basis of that. Not starting, not top down with hierarchical categories, but bottom up, by following what is happening. Not following the human person, but following every entity that is in the web of relation of every human person, and trying to constitute a legal system on the basis of that. Now I'm running ahead what I'm going to say, but almost behind my time. How many minutes have I got left? Yes, that will do. So now the modulation. We need a shift in, we need a modulation, not working with the 6 building blocks that I've presented before, but doing away with this hierarchy between relations between a human and other humans, and relations between humans and non-human entities. Not trying to only use these rigid categories, like the slide of Visa. These 2 categories are blurred. The colors that, yeah, I see what you meant with the colors now. These categories are blurred, and you need not want to apply this dichotomy between them. Those strategies don't work. What could work, but I don't know, it's an abstract exercise up till now, is to apply what Mariano and I call contractualization. We applied it up till now to family law relations because they're also very much blurred. Like we're looking into polyamorous relations and multi-parenthood and so on. So beyond the traditional building blocks. This can also be done or be applied to the relation between living human beings and other entities. Follow their points of contact in a web of relations. A web of relations, for example, between me and my spouse and the wedding ring we have is a web of relations in which we can describe the value of these different points of contact and make them legally relevant, contractualize them, so to say, and make this description of this reality in this web of relations legally relevant. The law makes the difference. So let the law make the difference in this specificity of the network we're engaged in. That is to say that what should also be recognized is not only the agency or moral, philosophical, ethical concept, of course, but not only the agency of the living human beings, but also that of the non-human entities in the network. Because I, too, as a living human being, am constituted by what objects are, which things are in my network. It's not only vice versa, the Hegelian tradition, I become a person by objectifying things in the external world. It's also the way round. An object can influence me. And so we should also legally recognize that agency of the objects in the network. So this should become non-hierarchical. It's not about the human beings in the networks. It's not about the non-human entities in the networks. It's about their relations and the nodes, the connecting points where they find each other. And which nodes or connecting points are essentially contingent because they depend in a lateral way from where they find themselves in space, but also where they find themselves in time. A ring can be something very different if it's my ring now, or if it's the wedding ring of my grandparents. Teeth can be very different if it's a tooth that is that I want to get out now by the dentist, or it's a golden tooth of my grandmother that I found in the attic. It depends. It's very contingent on the specific network. And so this is what Mariano and I call the relationist and anti-essentialist approach towards the law. Can this be done? Is this not a very abstract exercise? And how do you apply this in legal technique? By, we think, returning to objective law, getting away from the concepts of person and thing and rights, doing away with them, and returning to objective law. Objective law on relations, not on entities, not on persons or things. Whereas, of course, animal or a human or chair could still be relevant entities in the law, but not in terms of rights and duties. At least not in terms of rights. So, contrary to this subjective law approach, rather than to have relations between human beings with respect to and to other entities, we can have relations towards other entities. That is where I think the move from rights to duties, that I don't have the right to exclude everyone else with regard to my the thing I own, but the duty to include other entities in the network. I have responsibilities we have towards an heirloom, towards the corgis of the queen, towards a house, to look after your house, even it's not a heritage, even if it's not important in terms of heritage. In an animal, to take care of an animal who was a companion animal or who worked for you. Relations directly with respect to those entities, we think in contractualization could be the right approach. One colleague then became very excited and said, "No, what this is crap what you're telling, and what about the rule of law and legal certainty?" And of course, it is a concern, but as Radin in her influential work on property also said, these identities are not to be made up each time and again in every single network. There are generalized identities. There is a general understanding, for example, that a wedding ring within a couple or a throuple might be significant. So you can start from the generalized identities, but allow law users to redefine them in their own network. And that, to quote Latour, would be to reverse the great divide of modernity, where Latour says, well, modernity is only a very short period in time, and rather than to keep on working with those building blocks, let's go back in history. Not so far in returning to Roman law, which is also very hierarchical, but trying to find a new non-hierarchical, fluid law. That's where I'm going to end.